Live across Melbourne.
When you're a renter, there is a power disconnect.
We need rentals. Not everyone can buy a house.
The government are putting this on us, the landlords.
VCAT processes are ridiculously slow.
It's crucifying renters.
On 774 ABC Radio Melbourne, Raph Epstein presents a special mornings forum, Victoria's Rental Crisis, with co-host David Whiting.
And welcome to our crucial conversation about a rental crisis right here at the ABC studios in Southbank. We've got a very enthusiastic audience, including David Whiting, Melbourne solicitor, who's usually here to give you free talkback. How are you, David?
Raph.
Great to have you here. Amy Frew is with us. Amy's Director of Client Services at Tenant Victoria. Good morning, Amy.
Morning.
Jacob Kane is with us. He's the President of the Real Estate Institute of Victoria. Hi there, Jacob.
Hi, Raph. Thanks for having me on.
And Lindsay Warren is with us. He is here to tell you how to get your problems sorted and why it's not going to take you a long time. Lindsay is the head of VCAT's Residential Tenancies Division. Good morning.
Morning, Raph.
I'm going to try to get to as many callers and also as many questions from the people here in the audience. Just be aware, we're going to try and rush through an incredibly complex problem. Two numbers to keep in your mind. I know they're not the best indicators. Number one, the number of bonds, as in the number of people who've put money aside in a bond, that number has shrunk for the first time in 20 years. It's not going, it's shrinking, even while the population is growing. Someone texted before and said, look, it's not always an accurate measure. I get it. It's not a great measure either if the number of rental households is shrinking and not growing. And in March this year, the Bureau of Statistics says there were only 3,809 houses and flats built in the whole of Victoria. That's the lowest monthly number recorded by the ABS since back in 2013. So we've got some issues, clearly. That's why if you're renting, you're struggling. And I know landlords have got their issues as well. But I might just start with the people who I'm going to appoint to represent our tenants and our landlords. Amy, you represent Tenants Victoria. What's it like being a renter right now?
It's really tough. You've already gone through some of the figures today, but renters are really struggling. We hear dozens of calls every day to our lines, people worrying how they're going to stay in their homes. The vacancy rate's hovering around 1% at the moment. This means that rent increases are through the roof and people are facing a choice of moving out away from their families and communities, or some facing homelessness. Issue, and we heard one of your callers before say the disparity in power between landlords and renters means that renters are really reluctant to ask for help. Sometimes they put up with things like heaters broken, mould in the house. They don't want to rock the boat because the most important thing to them is to hold on to their home. And the final point I'll make is just, as you've already said, social housing, it's so low in Victoria. It's at 2.9%. We're the lowest in Australia. Lower income renters really struggling. More social housing needs to be provided.
Jacob Kane from REIV, the Real Estate Institute. What's it like being a landlord right now?
Well, I think for most Australians right now in the economic environment we find ourselves in, they're finding it incredibly challenging. The cost of living pressures are mounting and taking a toll on Australians across the entire landscape, and rental providers or landlords are no exception in that respect. It's important to remember that the rental providers across Australia, the vast majority of them are individuals, couples and families that only own one property. They've fought, tooth and nail to get enough money together to put a deposit down on a property. Generally, that's an apartment as well. And their hope is that property will help secure theirs and their families', financial security in the future. Now, the landscape in Victoria has changed very significantly for property investment owners. The introduction of a whole raft of new legislation, an increase in compliance and minimum standards, as well as the introduction of a raft of different property-related taxes has changed the calculus definitely for a lot of property investors. But the reality is it's an evolving context, and everyone who's operating in that system, whether it be a renter, a rental provider or a property investor, they've needed to adapt to meet those changes.
So Jacob and Amy have got some areas of common ground, some real areas of difference. If they come to you, David Whiting, either a tenant or a landlord...
Raph, I need to know which. My answer will be different in both circumstances.
Well, no, it might not be. Is anybody going to get a fair resolution or a fast resolution?
I had the privilege of talking to Lindsay last week. Can I say you've got to go to VCAT because it has exclusive jurisdiction except for some weird constitutional provisions. And the rate of change of hearing applications at VCAT has changed extraordinarily. So the answer would be, you think about it, if I've got a complaint and I make it today, I want an answer tomorrow. But as a matter of logic, you've got to be able to give the respondent to your claim, whether you're a landlord or a tenant, an ability to prepare and then to be heard. So you're off to VCAT. My view is that 99 times out of 100, they'll give you, these days, a quick and a fair answer, even if it's not the one you're looking for.
When you use the word, I will ask Lindsay who runs this in a moment, but when you use the word quick, what does quick mean for most people?
Weeks. If it's urgent repairs, it's 2 business days, I think. But otherwise, I would have thought 6 to 8 weeks is a reasonable time to get a conclusion. Mind you, if you're looking for a bond refund and you need to pay my first month's rent and my bond for the next premises, that's not nearly quick enough.
No.
Yep.
Lindsay Warren, you run the most exciting part of the Victorian Civil and Administrative Tribunal, the residential tenancies list. That's right, yes?
Without doubt, it's exciting every day of the week.
I got an email yesterday from, I think it was Amy. She was a 44-week resolution at VCAT. I got an email from a woman, Rachel, overnight. Her resolution, I think, took 3 years. I realise there are outliers sometimes. How long are people realistically going to have to wait if they bring their dispute to VCAT?
It's no state secret we've had massive backlogs because of the pandemic. The impact of the pandemic on the tribunal's operations was significant. Pre-pandemic, we were a totally paper-based operation and all of our hearings were conducted on a face-to-face basis. Literally overnight, we had to close the doors to the public and we had to reinvent the way we worked to be able to try and keep the system moving. The impact of that is, sadly, big backlogs arose and we have been working very hard to try and reduce those. We understand every single one of those matters represents people who have a dispute and it's a significant dispute in their life. And we are working as hard as we possibly can to reduce that backlog, to hear and determine these matters and to get the system back on an even keel. If it's a matter that was in the backlog, there were delays, but we started the current backlog program in October of last year and we had approximately 23,000 cases that we needed to hear and determine. As at this morning, we're down to 5,685. So that is a significant turnaround in a very short period of time. It is a result of an extremely hard-working team at the tribunal. There is a lot of work still to go, but we are a long way towards solving that problem.
And that, I assume part of that's a resourcing issue. So if you cut 23,000 down to 5,000 since October, are those resources going to stick around? Like, has the government said, yep, keep going at the current rate?
Yes, there was a large appointment of new members or magistrates or judges in the tribunal, the decision makers, appointment of a large number just prior to Christmas and just after Christmas, which we are applying towards the backlog, but they will continue on once the backlog has been eliminated, which at this point in time our modelling shows that we will have all of these matters heard and determined by the end of this calendar year.
That's Lindsay Warren, who's the head of VCAT's Residential Tenancies Division. I've got questions here from the people in the audience, but I want to go first to Dora, who's called from Banyule. Dora, I'm assuming you can hear us all. Ask your question and ask who you would like an answer from as well.
I'm sorry, I didn't hear who was there.
Lindsay Warren's here from VCAT and David Whiting's here as well, and you can ask Amy from Tenants Victoria or Jacob from the Real Estate Institute. But why don't you explain your situation and then say who you'd like to answer?
Okay, well, perhaps the lady from VCAT.
Sure, Lindsay Warren's a bloke, but that's okay, go for it.
Sorry. Okay, so part of my question was answered on how to prioritise cases that live here. However, there are other items that arise that doesn't seem to have a flag to get anybody's attention. I certainly had the experience that I feel that if an application is placed on behalf of a tenant, it gets heard a lot faster than on behalf of a landlord. I've got a situation where I have placed an application on to vacate a tenant for their own good so they can get the assistance that they need, because they were told by a government body that they need a VCAT order for them to be able to assist it. I don't even have a date yet.
Okay.
And we're talking about a lady in her 80s and can't function up and down the stairs, the property anymore.
Okay, and I think I understand where you're coming from there, Dora. I understand, Lindsay, as you're a tribunal, it's harder to answer about specific queries, but that her sentiment, tenants get heard more quickly than landlords. Is she right?
Look, I'm sorry to hear that is the perception that you have, but overall I wouldn't agree with that statement. There are some applications by renters or by tenants which under the law we need to give precedent to, and we need to hear them within a very short period of time. David mentioned earlier that applications for repairs, particularly urgent repairs, we need to hear those matters within 2 business days of them being lodged. As a
to interrupt, Lindsay, does that mean if the tenant says it's 2 days or the landlord says it's 2 days, are those things treated differently? Who definitely gets that priority?
Well, if it's a renter application seeking repair orders, we have to deal with it within 2 days. So we don't have a say in it. That's what the law says we have to do.
Can I add, Raf, that Dora's question seems to me as much about a guardianship application as dealing with the capacity of the tenant. Now, it's possible that the tenant, in the circumstances Dora described, is not in default under the terms of the tenancy agreement, just simply doesn't have the life skills at this point to live appropriately.
It's about 17 minutes after 10. You're listening to 774, because that's what we call this radio station. Mark's got a query. You're a tenant, is that right?
That's correct, Raf. As a tenant, a couple of weeks ago, I had the great misfortune to be a party at a hearing of the Residential Tenancies Tribunal. To my complete astonishment, the other side, the landlord, brought along a lawyer to the hearing. Now, my question to Lindsay is, when did the Residential Tenancies Tribunal allow lawyers acting on behalf of landlords to operate to the complete disadvantage of tenants?
Lizzie?
First of all, Mark, I can't talk about your particular case, so I can't discuss any of those details. VCAT was set up as a tribunal primarily to allow people to represent themselves in hearings. Having said that, provisions in the VCAT Act do allow parties to be represented in certain circumstances. The legislation talks in terms of professional advocates. The definition of a professional advocate includes a lawyer. It also includes a property manager who might be representing a landlord. In my experience, and I've been on the tribunal for more than 20 years, in my experience it is more often, significantly more often, that a tenant will turn up with a lawyer at a hearing rather than a landlord. There are certain types of applications, possession applications, where there is a specific exemption that allows a party to be represented by a professional advocate. Now, I don't know what type of matter yours was before the tribunal the other week.
Lindsay, are there particular matters where, you can't have a lawyer? Or, what are the general rules about when you can and can't have a lawyer?
There are no specific rules when you can and can't. As I say, for possession applications, there is an exemption that allows for professional advocates to represent parties.
Yeah.
If one party shows up with a lawyer and the other one does not have a lawyer, the member hearing that matter has an obligation to ensure a fair hearing for both sides.
Does sound a bit imperfect, though. I'm not pinning that on you, but that's unequal, isn't it?
Well, part of our role, as I say, we have an obligation to ensure a fair hearing. If we feel that there is a party who may be struggling because they're not represented, we may stop the hearing and recommend that that person seek some legal advice.
Can I get some legal advice now? David, briefly, broad question. I'm going to go to VCAT. I might be a landlord. I might be a tenant. Do I need a lawyer?
Well, Lindsay talks in terms of professional advocate, which is immediately in terms of the question, Mark's question, is creates an imbalance in engagement, right? Whether it's the property manager from the estate agency or a lawyer or just a next friend who comes along and provides assistance, you've got the imbalance. The only other option would be for someone else to provide a medium on both sides that's identical, and that's never going to happen.
Yeah.
And what do you do if the tenant's a lawyer and the landlord's an elderly immigrant? We've got an imbalance of skills at that stage.
David Whiting there. Lindsay Warren's the head of VCAT's Residential Tenancies Division. I'm going to get back to the people from Tenants Victoria and the Real Estate Institute soon, because I know there are issues beyond the disputes themselves. But Chris is in Corio on the phone. Chris, what do you want to ask?
Yes, good morning, everybody. I'm wondering why VCAT does have the power to enforce their orders. They can't issue fines or anything.
Lindsay Warren?
When the tribunal was set up, there was no power in the legislation that enables the tribunal to enforce its own orders. The legislation talks in terms of penalties that can be imposed for various breaches of the Residential Tenancies Act. Those fines or those penalties are sought by Consumer Affairs taking action in the Magistrates Court. Tribunal does not have the power to impose any of those penalties.
So anybody wants any action as a result of VCAT, I've got to then go off to another court, correct?
If it's to enforce a monetary order, then you need to go to Magistrates Court. If it's to enforce a possession order, then you apply to us for a warrant of possession.
Okay, sounds like we need to have a forum with some politicians here who know how to draft some new laws. But at 22 after 10, we've got Kate, who is over here. Kate, what's your question?
Hi, I'm a lawyer working with young people, and for my clients, their overriding concern is cost of living. Do you feel like the rental freezes will provide a solution to the rental crisis?
Might start with you, Amy, on rental freeze.
We definitely need regulation of rent increases at the moment. I'm sure you're seeing with your clients, and we hear every day from renters where there's no cap on the amount. We've been calling for a fairness formula, really just to make sure that there is some regulation, because as we know, housing is a human right. People need to stay in their homes and they need to have certainty of how much that's going to cost so they can plan for their lives. So absolutely, regulation is essential.
Jacob, rental freeze?
Yeah, this is a hotly debated topic, the efficacy of rental freezes. What I know is that there are people firmly on either side of the argument, but what I also know is that in many jurisdictions throughout the world, particularly Europe and the US, where they've trialled or implemented a rent freeze with the intention of a generalised positive impact on rental affordability, in most of those jurisdictions, they've wound those policies back. Now, you could probably pick apart the design and structure of the implementation of the policies in some of those jurisdictions, San Francisco, for instance, and say that that's the reason it wasn't effective. But I think if we look at the Australian context, as we've already, we're all cognizant of, we're in the midst of perhaps the most acute housing affordability crisis we've ever been in. Last year, the federal and state governments contemplated this, implementing a rent freeze very strongly and decided against it. And the reason they decided against it is because they believed that it wouldn't have the positive impact that it was intended to. And I'm not cynical about that. I don't think it was special interests that determined that decision. I think they assessed it on the merits and it wouldn't prove effective in this system.
Just back to you, Amy Frew from Tenants Victoria. That's the argument often from people like Jacob. There's something similar happening in the ACT, hasn't worked overseas. Are you confident it can actually work in the way you'd want it to work?
I'm not an economist, so I'm not going to say that I would know the exact formulation, but what we can see now is people need to stay in their homes. They need to be able to have safe and healthy homes and make sure repairs are being done and so forth. And the protection they need is being sure of their rent and how much their rent may go up. And that's something that's missing in the moment in the conversation.
Jordan Vandenberg is with us. You might know him by his online avatar, Purple Pingers. How many followers have you got, by the way?
I don't know.
Like hundreds of thousands or?
Like a couple.
Yeah. What question did you want to ask? Thanks for coming along, by the way. What do you want to ask?
I got a question for Jacob. Why do you continue to allow your members to break the law?
Thanks for the question, Jordan. Thanks for being here. Look, I'd start, not to bat that question away, but in simple terms, the Real Estate Institute of Victoria isn't a policing or enforcement organisation. We're a membership organisation. And so we don't, like VCAT, we don't have the power to actually penalise or reputationally impact on those people that are perpetrating. Sorry?
You can take a membership away.
Yeah, absolutely. I was coming to that. Yeah, so definitely we have reporting mechanisms where people are members of the general public, renters, sellers, buyers, etc., who feel that they've not been treated appropriately in line with the legislation or ethically. They can report that to us. We'll investigate, and in the event that they're found guilty, we'll terminate their membership. And like you, we absolutely condemn those that are out there abusing the system, abusing the rights of renters and exploiting the system and exploiting people out there in the rental system.
Jordan, just a quick follow-up to you. I guess you've sort of made a name for yourself highlighting the shoddy stuff that's on offer. How much is that a big problem and how much is that just a few bad apples?
Yeah, I think we talk about it as a few bad apples, but I've been doing this for 3 years and I find new properties every day and new examples of real estate agencies and real estate agents breaking the law every single day. So how many bad apples does it have to take before it's a problem, I guess, is the question.
David, if I can throw that to you broadly, is that a whole lot of examples someone like Jordan might sort of end up, I guess, effectively reporting on, like putting on his socials.
There is a bad rental providers list at VCAT. So it is possible for VCAT to prepare a publicly accessible register of misbehaving landlords. So that's there.
Jordan's just saying there's only 16 on that list. I think he's
so
pointing
far.
out. Yeah, so far. Right.
So far. But it requires someone to start the process.
And as someone who provides legal advice, is it a good place to go? Am I going to get a good resolution to my complaint if I walk in somewhere and I think that's not something that should be offered, that should be illegal? And do you think people have a good chance of getting it remedied through the law?
The problem in part, Raf, is that there's 500 pages in the Residential Tenancies Act that not everybody knows perfectly, even Lindsay. You couldn't quote too much of it.
Yes.
That's the process and there is nowhere else to go. I now know that while Lindsay talked about the backlog, he didn't talk to you about the rate at which they're currently dealing with complaints. So there are between 55 and 60,000 applications made to VCAT in the residential tenancies list each year. So the real question is, how long does it take?
That's 1,000 a week.
1,000 a week. How long does it take to process them?
Lindsay?
If it's an application seeking a possession order, you'll get a hearing date in about 2 to 4 weeks after you lodge your application. If it's an application seeking or an application in respect to the bond or compensation, you're looking at a turnaround time of about 8 to 10 weeks at the moment from lodgement to hearing. 55,000 matters a year. Putting that into some sort of context, if you assume that there's at least 2 people involved in every one of those disputes, every year we deal with more than enough people that would fill the MCG on grand final day.
And just a quick follow-up, there's a residential resolutions body that the state government's spoken about setting up. I think they announced that about 6 months ago. Have they spoken to you about that?
To me personally, no.
To VCAT?
I'm not aware of all conversations between government and the tribunal heads. Sorry to interrupt.
There's no conversation between the government and anybody at VCAT about an alternative to VCAT in the last 6 months?
I'm not aware, but that's not to say conversations are not happening. My own personal view is the work that we've been doing in the backlog program to hear and determine the matters in the backlog, other work that is being done in the residential tenancies list, will go a long way towards providing essentially a one-stop shop. If you consider a freeway, a dispute is lodged at the tribunal, people start along the journey on the freeway. At the end of the freeway is a formal hearing. But on a freeway you have a number of off-ramps. And what we're building is a system that provides those off-ramps. So there's opportunities for early resolution.
Sure.
So people aren't locked into going to a hearing in relation to every dispute.
Okay.
We think we can provide a one-stop shop. My own view, we can fulfil that role that government has announced, but at the end of the day, it's a matter for government.
That's Lindsay Warren, who's the head of VCAT's Residential Tenancies Division. David Whiting is here. You heard before from Amy Frew from Tenants Victoria and Jacob Kane from the Real Estate Institute. Gina's here. You're a landlord, Gina, is that right?
Yes, thanks, Raph. I'm here to represent my family, who are landlords and have been for many years. Just wondering, panel, if there's been any research done to suggest tenants are better looked after if they deal directly with the landowner.
As opposed to an agent.
As opposed to an agent, exactly.
I might start with Jacob.
Thanks for the question. I'm not aware of any explicit research that's measured qualitatively the difference between like a private landlord and a real estate professional managing the property. Anecdotally, and we spoke about this earlier, the complexity of being a manager of a rental property has increased dramatically over the last 4 years. I, for instance, have a friend who self-manages a property of theirs, and I can tell you that I know without question there are areas of non-compliance where they haven't met the minimum standards. Now, this is someone who's absolutely well-intentioned, would consider themselves a stand-up landlord, someone who's generous with the rental rates, doesn't increase the rents, but no routine inspections conducted, no fixtures, like breaches across the board.
Yeah.
Under the current conditions, that person could conceivably, be held on criminal charges for renting out a property for non-compliance. So I would hazard a really strong guess that real estate professionals would be shown to be better managers of property across the board than private investors. And that's not to denigrate private landlords. It's just that they don't have the expertise to do it at the levels that professionals do.
I've got to get to some news. Of course you would say that because you're from the Real Estate Institute. But just very quickly, Amy, just in your tenants' experience, a brief answer if you can, better to have an agent to deal with or a landlord themselves?
What it comes down to is, like Jacob said, understanding of the law. So professionals may have a better understanding of the law, but landlords need to keep in mind it's their responsibility, it's their obligation to keep their house safe and obey the law. Yeah.
Okay. We'll be back with more of your questions on the phone and also from here at the forum, but let's just go to the newsroom.
On 774 ABC Radio Melbourne, Raph Epstein presents a special mornings forum. Victoria's rental crisis, with co-host David Whiting.
David Whiting and Lindsay actually were just talking earlier about getting on the bad renters list. How do I, like, just say I've got real ambitions in life, Lindsay. I want to get on the bad landlords list, the bad rental providers list. What do I have to do to qualify?
One thing we've touched on a couple of times already, minimum rental standards. Renting a house that does not meet those minimum standards. The renter can then make an application to the tribunal for a repair order. If you don't then comply with that order and do the repairs, you're a good chance of ending up on that register.
Okay. David, is it, I mean, I guess Jordan Vandenberg's point before was that if there's only 14 people on the list, it's not really effective. Do you think it's hard to end up on that list?
We start from the premise that the world works on the premise that everybody, once they know the law, will obey the law. Right? I mean, I've got 2 clients at the moment who are proposing to enter into rental agreements at what I would consider to be significantly less than market rent on the basis that they take the properties as is.
Yep. Now,
we now know from today's forum that they will then be committing a criminal act should they do that. Right? So, yeah, would I like to be on the list? No, but I don't have a rental property, so that's not a problem. But I can just see that I think it would require someone to in fact ask the tribunal to add them to the list. Yes, they can do it from their own volition, but it would be up to the renter to say, I think this should be on the bad renters list.
Amy, there's various ways you can solve a dispute, and you might sort of turn up on social media, or you might send an email to me, or go to a paper. What's it like, do you think, for most tenants when they have an issue? Is the system working?
For most renters that we hear from, they're really scared actually of what might happen if they do raise an issue. So we often hear people queries calling up saying, I've looked at your website, it says I should go to VCAT. I actually don't want to go to VCAT because I feel like that's escalating it too much. I want to try and resolve it, amicably, because at the end of the day, they're in an ongoing, contractual relationship with their landlord, and they have to rely on that person, and they're worried, if they might get an eviction notice as a result of making a request. So people are seeking to try and resolve it simply and quickly. But what's really important, again, we shouldn't be bargaining away our rights. So it's really important people understand what their rights are, and they know how to ask for them and the different forums they can do that in.
And Jacob Kane, on behalf of the real estate agents, or I guess on behalf of landlords, I have tons of landlords text me and call me and say it's hard. How do most landlords feel the dispute resolution is going?
Look, I think their experience is very similar to renters, acknowledging that perception of a power imbalance. VCAT at its best can be incredibly effective and efficient, a forum in which disputes can be resolved, simply and fairly. I've had the privilege, I suppose, of having Deputy President Moran preside over a matter that I was representing a client for, and in every respect he was exemplary in his interpretation and application of the law. He was empathetic to the parties involved and clear in the communication. That's VCAT at its best. But as we've heard today, delays, inexplicable delays. Sometimes you can lodge two almost identical applications on the same day and have a hearing for one in a couple of weeks and not have a hearing on the other for months on end. And the same can happen with decisions, sort of seemingly inexplicable decisions when you're presenting basically the same case and have diverging interpretations of the legislation. And I suppose that for rental providers, for renters and for real estate professionals, that kind of murkiness in the legislation, which has been referred to, is difficult to navigate.
And I just wanted to follow up with both of you, because Lindsay Warren, I might get in trouble, but I don't think there's been too much communication between the Victorian Government and VCAT about this new renters dispute resolution body.
RDRV.
Thank you.
Yep.
Amy, have they chatted to Tenants Victoria? Has the government spoken to you about this new body?
They have, yeah. We've talked to them about their ideas. I understand they're still in development phase. What's important for us is that renters still get a fair outcome. So we want to make sure that the power disparity that's already exists isn't increased in that kind of forum, and that's why there are many decisions that should be going to be decided by a VCAT member.
And Jacob, just briefly, have they spoken to you about this new body?
Same, yeah. We've had some consultation and input into the design of it. We're super keen to see where it lands in terms of its jurisdiction and the scope.
Sure.
Yeah.
Okay. Di is here. You are... What's your role in this dispute?
Hi, I'm a real estate agent, I'm a landlord and a tenant.
Okay, great. Trifecta.
Yeah, trifecta. So I see it from all sides. So basically I just wanted to ask my biggest feedback that I'm getting from my clients is that they are done, that they're wanting to sell up and they're done with the whole thing and they want to invest their money elsewhere than the Victorian property market. So my question is, what do you think could be done to keep investors in the market, to keep the stock levels up, the rental stock?
I'm going to start with Jacob, with you.
Yeah, absolutely. Thanks for the question. Look, the Real Estate Institute of Victoria has advocated strongly for the government to pivot in terms of its strategic posture around investment in property in Victoria. They've taken an approach of really disincentivizing investment through additional taxes and legislation, etc. We think that with whatever your view on it, the reality is that the vast majority of rental properties are provided by these private investors, and we need to encourage them to either remain in the system or, if possible, enter the system, just so we've got enough rental properties. Things, for instance, like land tax. Land tax has gone up very recently, and it's been a big issue. How about alternatively, if a rental provider was prepared to commit their property to the long-term rental market for 5 or 10 years, could they enjoy a discount on their land tax, to keep them in the system rather than leave them? Because one of the big things in our sector, as in a lot of sectors, is sentiment, and sentiment is very poor at the moment.
Okay. Amy, some applause there. But Amy, just briefly, does Tenants Victoria have a view on the land tax issue? It's clear someone rang this morning, I think it might have been Margaret, he was in Ballarat. Land tax went from, I think, about $800 to $4,000 a year. Do Tenants Victoria have a view on land tax? Land tax is outside of the sort of normal concepts that we think about. But just go back to the question from before. When an investor sells their property, that's bought by another investor or by a home owner who's going to live there. So the property still remains in the market providing housing for someone, just perhaps not for that investor. Okay. There's actually a question for you, Amy. Fred is in Craigieburn. Fred, what do you want to ask?
Yeah. We've lodged an application with VCAT. Unfortunately, we still haven't heard. Now the landlord is threatening to evict us. So we want to know, where do we go from here? Maybe Amy can answer that for us.
Amy? I'll go to David as well, but Amy?
Well, I would say, first of all, seek some legal advice. Call Tenants Victoria on the advice line or have a look at our website. It's hard to comment specifically on where it's up to, but I can say contact VCAT and ask where your matter is up to if you have filed a matter in VCAT, and maybe Deputy President Warren will want to speak to that.
I might just get Fred, how long ago did you lodge the application?
About 2 months ago.
Okay. David Whiting?
Well, that's longer than Lindsay's expectations as to a response. So,
if he's threatened with eviction too, David, I'll come to Lindsay in a tick. David, what is there?
Well, there needs to be grounds. The rules in relation to eviction changed substantially a couple of years ago, and the process that you need to follow to bring a tenancy to an end are, I would have thought, very difficult from a landlord's point of view, far more difficult than they were. There's no such thing as an eviction for no reason. So I would be, in a sense, discounting the threat, but that may depend upon what the complaint is.
Yeah, okay.
And what we might be doing is making the point to... My problem with the rental market at this stage is trying to balance the tenant and the landlord, because the external pressures... The tenants have incredible pressures in terms of rent affordability, and the landlords are continually looking at, well, what might else might I do with the money I've got here if I'm not getting a return that represents what I might get elsewhere?
And Lindsay, do you have anything to add to that?
Well, in terms of the comment about the delay, I don't know what sort of application it's been lodged, but if they've not heard anything to date, ring the tribunal and see where it's at.
Okay.
In terms of the threat of eviction, I mean, I agree with what David said. The rules around landlords seeking to evict tenants have changed significantly since March 21.
Although I can hear, there's quite a few people here who think it's actually quite easy to evict without a reason.
No, I wouldn't agree with that.
David?
I've advised 4 clients in the last week about how the eviction notice that they've received is defective. So you get lots of defective eviction notices.
Yeah. The rules around notices to vacate are very technical.
Yeah.
And the Supreme Court has said that there must be strict compliance. So there are a lot of notices to vacate are issued every year, but most of those don't result in tenancy applications. Just before I go on, if the caller is concerned that there is a threat of eviction, first of all, they need to be given a notice to vacate, and it comes to the tribunal.
Yes.
Depending on the grounds cited for that notice to vacate, there is a provision that says that we can deem a notice ineffective if we form the view on the evidence that it is given in retaliation to a renter exercising their rights under the law.
But I've still got to feel as a tenant that I've got the time and the patience to run that through VCAT, right? Like that's the issue, isn't it? Someone gets a notice and they're scared.
They are scared, but we're the umpire in the system.
Yeah.
we are where they come to get that sorted out.
I might come to Amy Frew again from Tenants Victoria, but I'm going to add another call into the mix because it's a sort of a similar issue, I think. Karen, you're in Mount Martha. I think you're calling about your daughter. Do you want to explain what's going on and what your question is?
Just what protection does the tenant have from eviction when they complain to the landlord, who is also the managing agent, say when no repairs have been done and the rent has gone up in 12 months, $100 a week?
So just to clarify, your daughter's asked about repairs and now fears that she's sort of being targeted for eviction because she asked about repairs. Is that what you mean?
She hasn't actually ever received an eviction notice. However, the agent just declines to accept that things need repair.
Okay. Amy Frew, can you answer some of that?
Yeah, so I mean, that's a really common query we have is people are wanting repairs done. They're worried about the impact of making that thing. As we've heard, that if there's it seems like it's retaliatory to have an eviction notice be given for asking for something, VCAT can find that notice is of no effect. But the other thing I would say, if you're not getting any traction as a renter getting repairs done, make that application to VCAT. They must hear it within 2 working days, and then they can make orders. And then as the matter goes on, if it still doesn't get repaired, they also have the power to order the renter to pay their rent into it's called the rent special account, and that's held effectively on trust while those repairs are getting done. So that is one tool the renter has that VCAT can order to try and get repairs done in a timely manner.
Just listening to all these answers, Amy, do most people get lost in the rules? I mean, I think I credit myself with I got some intelligence. I'm struggling to keep up with all of the, it sounds incredibly complex. Do most people drown in the detail?
It is really complex, but there are a lot of resources online out there and free legal assistance like Tenants Victoria and other community legal centres to get advice, but it is a complex system. VCAT is set up for self-represented renters and they should provide assistance in a hearing where someone's unrepresented. But I think taking the first step is the scariest part, trying to understand what your rights are and then what the steps are to enforce them.
It's 12 minutes to 11. You're listening to a special chat, forum, whatever you like to call it, about the rental crisis. We've got Jacob Kane from the Real Estate Institute, Amy Frew from Tenants Victoria, Lindsay Warren from VCAT, and David Whiting is with us as well. Anthony is calling from Carlton with a question, I think, specifically for Lindsay Warren from VCAT. Anthony, go for it. What would you like to know?
Yeah, look, there is an issue of Airbnb which hasn't been discussed, but I won't get into that. I'm a pensioner and I've applied for a review at VCAT. And I was told that I couldn't get the concession rate because I have a pension card, not a healthcare card. And yet the pension card is a superset of the healthcare card. And I'm now stuck in a situation where the application can't proceed.
Right. What's the difference in the discount?
It hasn't been paid properly.
What's the difference in the discount between pension card and healthcare card?
Well, it should be the same. I mean, they're just not recognising the pension
what's the
card
discount
at all
worth?
as a recognition for the concession.
Okay. Lindsay Warren, I'll put that to you. Why the distinction?
Look, thank you for the question. To answer your question, Raf, the difference is the normal application fee is about $65. Concession is a waiver of that fee, so the applicant would pay nothing.
Okay.
The difference, the rules around fees and fee waivers are all set by government regulation, so we have to apply those regulations as they exist.
Okay. I want to give Lynn Hultane a go. Lynn is, of course, part of the grand tradition of being a presenter on this radio station. Lynn used to present breakfast. Who are you with now?
The Victoria Law Foundation.
And what's your query?
I would like to accept entirely that there is a very immediate crisis and that's the heat in the discussion right now. But we need to look long-term too. So what kinds of diversity can we put into rental agreements to improve the options for both renters and landlords down the track? For example, Europe, 10, 20, 50-year rental agreements, which gives everyone stability. Why don't we have that here?
Feel like I'm on radio, on breakfast a little while ago. But Jacob, great question, right? Don't we need more long-term rental systems?
100%, yeah. We as a society, we need to continue to shift. We're doing it at the moment, but probably slower than we need to this concept of lifelong rental. and we need systems and structures that support that. Longer term rentals, there's a huge appetite amongst the rental provider cohort here in Victoria and around the country that would love the security of a 5, a 10, a 15, 20-year rental. They're the people that have gotten into property investment for the long term.
And landlords are interested in that?
100%, yeah. A glimpse behind the curtains, it's cheaper for them, right? They don't need to lease out the property. They don't have vacant periods like that. Someone that's prepared to commit to 10, 15, 20 years, they're going to love that property like it's their home, right? And probably invest in it themselves. So it's a really attractive proposition for those that are committed to the longer term rental market. We have the counterpoint to that is that we also have a society that is evolving in different ways where permanency is less of a draw card than it was.
Although more and more renters, right? We're going to go way beyond a third of people renting.
That's right. Yeah, that cohort's massively increasing, and a significant number of that cohort aren't interested in a mortgage or a long-term lease. They want to be portable. They want to be mobile. They want to shift between cities. They want to shift to where work is, to where the lifestyle suits them. That's an increasing contingent as well. So we need the right mix so we can make sure that everyone's catered for and we have a safe and equitable rental housing system.
Amy, a lot of renters interested in longer term rents, I'm assuming yes.
Yeah, I think they would. There's security. And like you say, it's their home. They want to, plant a tree or, set up the house in the way they want to have it. At the moment, people could enter into, there is the provision to enter into long-term leases, but I think culturally we're still sitting back at the idea that one day we'll own a home, and that's really holding back, I think, people, conceiving lifelong renters. As Lynn said, in other countries, people would never think they were going to, and that's no disadvantage. They're not a second-class citizen, and we need to move into thinking about it like that.
Why aren't governments interested in much more long-term rental being reflected in the law? Amy and JP, I'll start with you, Amy. Why aren't governments around Australia interested or doing this or talking about it?
There's a provision right now. You could enter into a long-term lease. The Residential Tenancies Act has provision for leases under 5 years and over 5 years. So it's there. It's able to be taken up on. I think it really does go to that shift. And instead of incentivising, for example, people entering into the housing market by purchasing, could be incentivising people into a stable, secure rental market.
And incentivise how?
Well, there's more, rental protections that we could have. So at the moment, we heard the no fault eviction. We do have the end of the initial first term, which is the sort of after the first year, a renter can be evicted. I think the other incentives for renters are things that we think around, like minimum standards. So we have got much improved minimum standards, but we can go that extra mile. Insulation, things around making the home safe, comfortable and healthy. That's the next step we need to take in terms of minimum standards.
Okay. Lindsay, I just come back to you on VCAT and your hopefully shrinking list and not growing list of people. What's on your wish list? Is it as simple as you could just do with more humans staffing VCAT?
Look, Raph, that's really a question for government and policy.
I'm going to try and press you, though. I'm not asking you to suggest a legal change, but I am asking you if you've got enough to do everything you're being asked to do.
In any organisation, you could always do with more. And to that extent, the tribunal is no different. We're looking to change the system, to improve the system, to provide a better system for the community, which is what our role is to do, and to be able to hear and determine disputes as quickly and as fairly as we possibly can.
Okay.
Can I just pick up on one point that Jacob mentioned in an answer a few minutes ago about the two applications lodged at the same time? One goes through quicker than the other, on the face of it the same application, but they come out with different answers. There is significantly more to it than just that. As a tribunal member, I can only make a decision based on the evidence that is presented to me in a hearing. You can have two applications for possession for unpaid rent, for example. One, the possession order might be made, the other one it won't be made. Why? Because of the difference in the evidence, the difference in the circumstances that we need to take into consideration. One of the significant changes made to the law around possession applications back in 21 was the introduction of what we call the reasonable and proportionate test. I mentioned before that notices to vacate have a lot of strict compliance requirements. A landlord can tick every one of those boxes and their notice to vacate is perfectly valid. Every I is dotted, every T is crossed. But then when you take into consideration the reasonable and proportionate test, that can sway the decision from making a possession order to not making a possession order.
Okay.
We have no choice in whether we take that reasonable and proportionate test into account. We must consider it. And if at the end of the day we find it is reasonable and proportionate, taking into all of the circumstances of the landlord and the tenant, we will then make a possession order. If there is evidence which satisfies the tribunal that it is not reasonable and proportionate, then the law says we must dismiss the application. In terms of different decisions and reasons for decisions, it can come down to the evidence which is presented. And that's a big difference behind the scenes that we have to work through, and we have to work through fairly on each occasion.
I'm going to go to a quick question from Stephen. If you can, keep it as fast as you can, because we've only got a few minutes. Go for it.
G'day, thanks very much indeed, Raf. Raf, this is for Lindsay from VCAT. My mate Mark and I are Australian Defence Force veterans. We live in a veterans village. I would like to ask if there is a provision at VCAT under the legislation to declare a landlord a vexatious litigant or similar. As a case in point, a veteran, not me, was subjected to 3 different eviction moves within the space of 6 weeks early in 2023.
Okay. Is that possible? Someone deemed vexatious as a landlord?
There are laws that a court or the tribunal can declare somebody to be a vexatious litigant. It's not a simple process to go through, but the law does exist to do that.
David Whiting, I'm going to give you one of the final, maybe the final say. Should people feel hopeless if they've got a problem with their renter or their landlord?
No.
Why not?
No, I think it's a question of taking the next step by being well informed, whether it's talking to Tenants Victoria or somebody like them in terms of getting, if you're going to VCAT, if you want to see the claim through, you really need to go in well informed and not just operating on your gut. But if there's something I'd like to see, going to VCAT takes time. So it takes time out of the day. There's an involvement from a landlord and a renter's point of view. I'd actually like to see some evening sessions at which the skills could be used, say, in a magistrate's court for a period of 3 or 4 hours rather than the building at 55 King Street or their other place.
We'll put that on the table as a suggestion for next time we get Lindsay Warren on the radio. If everyone can put their hands together for Jacob Kane, Amy Frew, Lindsay Warren and David Whiting. Thanks to everyone who came along today. I'm sorry if you didn't get to ask a question. Thanks to everybody here at the ABC. There's a huge team of people who got this little chat together, so I want to thank every one of them individually, those down here and those upstairs. And don't forget, if you want to get in touch with us about anything on the show, including a changing track, it's raf@abc.net.au.